Something huge just happened at the Supreme Court, and gun owners across America are trying to figure out what it means before the effects spread even further. An emergency ruling from the highest court in the country has triggered a wave of confusion, concern, and intense legal debate. Some people are calling it one of the most important gun rights developments in years. Others are warning that the headlines are moving faster than the actual facts. But one thing is already clear. This decision has shaken the national conversation around firearm permits and constitutional rights in a major way. Because when the Supreme Court issues an emergency ruling tied to gun laws, people immediately start asking serious questions. Will permits change? Will restrictions disappear? Will states lose authority? And most importantly, what happens next? Right now, those questions are spreading across all 50 states. And the reason this situation feels so explosive is because emergency rulings are different from normal Supreme Court cases. They move faster, they happen under pressure, and they often arrive before the full legal battle is completely finished. That's exactly what happened here. Behind the scenes, legal teams rushed arguments to the court. They claimed immediate action was necessary. They argued that constitutional rights were being affected in real time and that waiting months for a normal ruling could cause lasting harm. The Supreme Court agreed to step in, and when it did, the legal landscape shifted almost instantly. Now, before we go further, it's important to understand something clearly. The court did not literally eliminate every firearm permit in America overnight. That's not what happened. But the emergency ruling did challenge the legal foundation behind certain permit systems and restrictions. And that's why this story is becoming so significant. Because the ruling appears to strengthen constitutional protections surrounding firearm ownership and carry rights in ways that could affect how states issue permits moving forward. And for many legal experts, the bigger issue is not just one permit law. It's the constitutional standard the court is now signaling. That standard could reshape future gun rights cases nationwide. To understand why this matters so much, you have to look at how firearm permit systems developed in the first place. For decades, states created different methods for regulating who could legally carry firearms in public. Some states adopted shall-issue systems, where permits must be granted if legal requirements are met. Others used stricter may-issue systems, where authorities had broad discretion to deny permits, even if applicants technically qualified. That difference created major legal battles across the country. Critics argued that discretionary permit systems allowed governments to unfairly limit constitutional rights. Supporters argued those systems were necessary for public safety and local control. Eventually, those arguments reached the Supreme Court, and over the last several years, the court has increasingly signaled stronger protection for Second Amendment rights. This emergency ruling now appears to continue that trend. The justices focused heavily on whether states can impose broad restrictions that make exercising firearm rights difficult or inconsistent. And according to legal analysts, the court's language suggests deep skepticism toward systems that give governments too much discretion over constitutional rights. That's the part creating nationwide concern among lawmakers and state officials. Because if future courts apply this reasoning broadly, some permit systems could face serious legal challenges, especially systems where officials can deny permits based on subjective standards rather than objective requirements. Now, this doesn't mean every permit law automatically disappears tomorrow. Far from it. States still have authority to regulate firearms in many ways. Background checks still exist, certain restrictions still apply, and courts will continue deciding where constitutional limits actually fall. But the legal foundation under discretionary permit systems may now be much weaker than before. And that possibility is exactly why attorneys across the country are already preparing new lawsuits. Some are targeting state permit laws directly. Others are challenging specific restrictions connected to firearm carry rights. And many are using the Supreme Court's emergency ruling as the constitutional basis for those arguments. That process could become enormous over the next several years. Now, another reason this ruling matters so much is because of the way emergency orders work. Unlike traditional Supreme Court decisions, emergency rulings often happen quickly without full, lengthy opinions. That means lower courts must interpret the signals carefully. Every sentence matters. Every phrase matters. And legal experts immediately begin debating what the court is really saying. That's happening right now. Some analysts believe the court is clearly preparing to strike down broader permit restrictions in future cases. Others believe the ruling is narrower and more limited than the headlines suggest. But even cautious experts admit something important. The direction of the court appears increasingly favorable toward stronger Second Amendment protections. That trend alone is enough to create major legal uncertainty nationwide. Now, reactions outside the courtroom have been intense. Gun rights organizations are celebrating the decision. Some are calling it a constitutional breakthrough. They argue that the right to bear arms cannot depend on government discretion, and that constitutional rights should not require officials to decide who deserves them. Meanwhile, gun control advocates are expressing serious concern. They warn that weakening permit systems could reduce oversight and create public safety risks. Some officials fear states may lose important tools for regulating firearm carry in crowded urban areas. And because the ruling arrived through an emergency process, critics argue the court acted too quickly on an issue with massive national consequences. That disagreement is only becoming more intense, because this ruling touches one of the most emotional constitutional debates in America: the balance between public safety and individual rights. And every time the Supreme Court steps into that debate, the effects spread far beyond the courtroom itself. Now, another major issue is how lower courts may respond moving forward. Some federal judges may apply the ruling aggressively. Others may interpret it more cautiously. That could create very different legal outcomes across different states and federal circuits. In one region, permit restrictions may survive. In another, similar restrictions could be struck down. And when lower courts split like that, the Supreme Court often returns later to settle the disagreement permanently. That's why many legal experts believe this emergency ruling may only be the beginning, not the final answer, but the start of a much larger constitutional transformation surrounding gun rights in America. At the same time, state governments are now under pressure to respond. Some states may begin rewriting permit laws preemptively to avoid future legal challenges. Others may defend their existing systems aggressively in court. And a few states could attempt entirely new regulatory approaches designed to survive under the Supreme Court's evolving constitutional standards. That creates a period of uncertainty nationwide. Because while the court's direction may be becoming clearer, the exact legal boundaries are still developing. And developing legal standards often lead to years of litigation before stable rules finally emerge. Now, another reason people are paying such close attention to this ruling is because of what it says about the Supreme Court itself. The court appears increasingly willing to intervene quickly when it believes constitutional rights are at stake. That matters, because emergency intervention used to be relatively rare in major constitutional disputes. But now, the court is showing it may act faster in cases involving rights it considers especially important. That shift affects legal strategy nationwide. Attorneys now know emergency appeals may have greater chances of success than before, and advocacy groups on both sides are adjusting accordingly. More emergency filings could follow in future gun rights disputes, more urgent constitutional challenges, more rapid Supreme Court involvement. That possibility alone could reshape how firearm litigation unfolds across America. Now, for ordinary gun owners trying to follow all of this, the legal details can feel overwhelming. But the core issue is actually simple. The Supreme Court appears increasingly skeptical of firearm permit systems that rely heavily on government discretion rather than objective legal standards. And if that constitutional direction continues, some state permit systems may face serious legal trouble in the future. That doesn't mean chaos tomorrow. It doesn't mean every permit disappears overnight. But it does mean the legal foundation beneath certain restrictions is now under heavier constitutional pressure than ever before. And that pressure is already spreading through courts across the country. As more lawsuits are filed, as more judges weigh in, and as states begin adjusting their laws, the full impact of this emergency ruling will become clearer. But today, one thing is already obvious. The national debate over firearm permits and constitutional gun rights has entered a completely new phase, and the consequences of that shift may reshape American gun law for years to come. Now, as states, courts, and legal experts begin reacting to this emergency Supreme Court ruling, the bigger picture is starting to emerge, and many believe the real constitutional battle may only now be beginning. Because once the Supreme Court signals that certain firearm permit systems may conflict with constitutional protections, everything connected to those systems comes under pressure. State laws, licensing procedures, carry restrictions, application standards, enforcement practices, all of it. And right now, officials across the country are trying to determine how far this ruling could eventually reach. Some states are already reviewing their permit systems internally. Legal teams are examining whether current laws rely too heavily on subjective standards that courts may now reject. Other states are preparing to defend their systems aggressively, arguing that public safety concerns still justify certain restrictions. And between those two positions, a legal storm is beginning to form, because this issue goes far beyond one emergency order. It touches the core of how constitutional rights are exercised in America. Now, one of the biggest questions surrounding this ruling is what happens to states that still rely on discretionary permitting systems. For years, some states gave local officials broad authority to decide whether applicants showed proper cause or sufficient justification to carry firearms publicly. Critics argued those standards were too vague and allowed governments to deny constitutional rights unevenly. Supporters claimed they gave authorities necessary flexibility to protect public safety in densely populated areas. The Supreme Court now appears deeply skeptical of that approach. And if lower courts apply the ruling broadly, states may face increasing pressure to replace discretionary systems with more objective standards. That could become a major turning point in American gun law. Because historically, firearm regulations often depended heavily on geography. What was legal in one state could be heavily restricted in another. But if the court continues strengthening constitutional protections around firearm carry rights, the gap between states may begin narrowing. Not completely, but significantly. And that possibility is exactly why lawmakers are reacting so strongly right now. Some state officials fear losing authority over how firearms are regulated locally. Others believe the court is finally correcting what they view as years of unconstitutional restrictions. That divide is growing more intense by the day. Now, another critical issue is how quickly new lawsuits could spread. Gun rights organizations are already preparing challenges targeting permit requirements they believe conflict with the court's reasoning. Some lawsuits may focus on application delays. Others may target excessive fees or training requirements. And some may directly challenge broad restrictions on where legally permitted firearms can be carried. Because once the Supreme Court signals a constitutional direction, attorneys immediately begin testing how far that reasoning can go. That process is already underway, and it could reshape firearm litigation nationwide over the next several years. At the same time, courts themselves face a difficult challenge. How should judges balance public safety concerns against constitutional rights? That question has always existed in Second Amendment cases. But now, the Supreme Court appears to be shifting the framework lower courts must use when answering it. And that matters enormously, because legal frameworks determine outcomes. If courts apply stricter constitutional scrutiny to firearm restrictions moving forward, states may face a much harder time defending broad permit systems and carry limitations. That doesn't mean every regulation disappears, but it does mean governments may need much stronger legal justification than before. Now, outside the legal world, reactions among ordinary Americans remain deeply divided. Some gun owners see this ruling as historic progress for constitutional rights. They argue that carrying a firearm for self-defense should not depend on whether a government official subjectively approves your reasons. Many believe constitutional rights should operate equally for everyone, not selectively based on local discretion. Others are deeply worried. They fear weaker permit systems could increase risks in crowded public areas and reduce safeguards designed to keep firearms away from dangerous individuals. That emotional divide reflects the larger national conflict surrounding gun policy in America. And every time the Supreme Court intervenes, those tensions become even stronger. Now, another important detail is how this ruling may influence future Supreme Court decisions. Emergency rulings often provide clues about the court's broader constitutional direction. They don't always settle every issue permanently, but they signal how the justices may think when larger cases arrive later. That's why legal experts are studying every word of this ruling carefully, because the language suggests the court may increasingly view public firearm carry as a protected constitutional right that cannot be burdened too heavily by state discretion. If that interpretation continues developing, future cases could expand protections even further, and that possibility has enormous implications nationwide. Now, here's another reason this ruling matters so much. It doesn't just affect permits themselves. It could eventually affect every regulation connected to carrying firearms publicly. Sensitive place restrictions, transportation laws, training mandates, renewal procedures, application timelines. Each of those issues could become future constitutional battlegrounds, depending on how courts interpret the Supreme Court's reasoning. That's why legal analysts are describing this as a potential turning point, rather than just another gun case. Because once constitutional standards begin shifting, entire legal systems may eventually change around them. Now, state governments are responding very differently depending on where they stand politically. Some states are already discussing ways to strengthen existing firearm restrictions while attempting to remain compliant with the court's direction. Others are moving toward expanding carry rights voluntarily before courts force changes later. That creates another challenge: the possibility of major legal differences between states during this transition period. And when laws differ dramatically across state lines, confusion increases, especially for lawful gun owners who travel, because someone may legally carry in one jurisdiction but face serious restrictions immediately after crossing into another. If courts begin striking down portions of state permit systems unevenly, that complexity could become even more difficult to navigate. Now, another major concern involves law enforcement agencies. Police departments rely heavily on clear legal standards when handling firearm-related interactions. But if permit systems change rapidly through court rulings, agencies may need to update training, policies, and enforcement procedures repeatedly. That creates operational uncertainty, especially during traffic stops, permit checks, and public carry investigations. Officers need clear rules. Citizens need clear rights. And during periods of constitutional transition, clarity often becomes difficult to maintain. That's one reason legal experts expect this issue to remain controversial for years, because constitutional changes rarely happen smoothly. They unfold gradually through overlapping court decisions, legislative responses, and enforcement adjustments. And that process can take a very long time. Now, another important aspect of this story is what it says about the Supreme Court itself. The court appears increasingly willing to protect Second Amendment rights aggressively. That trend has become more visible in recent years, and this emergency ruling reinforces that perception. Some legal scholars believe the court is building a new constitutional framework around firearm rights, one that gives the Second Amendment stronger protection than lower courts historically provided. If that's true, future firearm restrictions may face much tougher constitutional scrutiny moving forward. That possibility explains why both sides of the gun debate are reacting so intensely, because they understand the stakes are bigger than one permit case. This could influence the direction of American gun law for an entire generation. Now, for ordinary Americans watching all of this unfold, the situation can feel confusing. Headlines move fast, rumors spread quickly, and social media often exaggerates legal decisions before the actual effects become clear. But here's the reality. The Supreme Court did not instantly eliminate every firearm permit in America. What it did was potentially far more important long-term. It changed the constitutional pressure surrounding how those permit systems operate. And that change may gradually force states, courts, and lawmakers to rethink firearm regulation nationwide. That process has already begun. New lawsuits are coming. New appeals are coming. And eventually, the Supreme Court itself may revisit these issues again with even broader rulings. Because once constitutional transformation begins, it rarely stops with one case alone. It grows, case by case, decision by decision, until eventually an entirely new legal landscape emerges. We may be witnessing the early stages of that transformation right now, and if that's true, the effects could shape American gun rights for decades to come. For now, one thing is certain. The national debate over firearm permits and constitutional carry rights has entered a completely new chapter. A chapter driven by emergency Supreme Court action, growing constitutional scrutiny, and rising legal uncertainty across the country. And as more courts begin responding to this ruling, the full impact may become even larger than many Americans realize today.